Welcome to the Deep Dive. It is so great to have you here with us today, whether you are listening on your commute, maybe prepping for a big meeting, or you're just insanely curious about how the machinery of the world actually functions behind closed doors.
Yeah.
You are in the exact right place.
Yeah, absolutely.
Because today we are opening the hood on what is arguably one of the most complex, most universally criticized, and yet uh, absolutely vital organizations on the planet. I am talking about the Internal Revenue Service, the IRS.
Right. It is the one agency that touches literally every single American's life. I mean, it doesn't matter who you are or what you do for a living, you have a relationship with the IRS.
Exactly.
And yet, for the vast majority of people, it remains a total black box. We send in our forms, we pay our taxes.
We obsessively check our bank accounts waiting for our refunds.
Exactly. And we just cross our fingers hoping we never get one of those terrifying thick envelopes in the mail. But what is actually happening inside that machine? When you hit submit on your tax software or when you drop a letter in the mail, where does it go? That is the mystery we're breaking down.
And to do that, we have brought in an absolute mountain of incredibly detailed primary sources. We've got a massive stack of documents fueling today's conversation.
It is a lot of reading.
It really is. We are looking at the National Taxpayer Advocate's 2024 and 2025 annual reports to Congress. And for those who might not follow the inner workings of the agency, the National Taxpayer Advocate, currently Erin M. Collins, acts as an independent watchdog.
Right, operating directly inside the IRS.
Yeah. Her job is to look at the system, find out what's breaking, and report it directly to Congress. We also have her specific Taxpayer Advocate Service blogs, a series of internal IRS strategic operating plans, and some highly specific, deeply technical cybersecurity and procurement guidelines.
Specifically focusing on an initiative called Pilot IRS.
Yes, Pilot IRS.
And reading through this mountain of documentation is just an eye-opening experience. When you aggregate all these reports, you really start to see the gears of this massive bureaucracy turning.
You really do.
You see the places where the gears are perfectly greased and operating with surprising efficiency. And you also see the places where those gears are grinding to a devastating, screeching halt, leaving everyday people caught in the middle.
So, what is our mission for you today? We are going to decode the IRS's ongoing massive technological and operational transformation. We want to answer the questions that actually impact your life.
Like why a tax refund, which you might desperately need, sometimes takes months to arrive.
Exactly.
Yeah.
Or how sweeping newly enacted tax laws are affecting the average person who is just trying to file a basic return. And what is the IRS actually doing behind the scenes to fix its notoriously outdated aging computer systems?
Because they are trying to fix it.
They are. Our goal is to give you a shortcut to understanding the absolute mechanics of the U.S. tax system without drowning you in bureaucratic jargon. Because believe me, the jargon in these federal reports is incredibly thick.
Okay, let's unpack this. Starting with a trip back in time. We need to talk about the technological time machine that the IRS is currently operating in, stretching all the way from the 1960s to the modern cloud.
Yeah, to understand why the IRS struggles so profoundly with technology today, you have to realize that they weren't always behind the curve.
Right.
In fact, they were pioneers. In the early 1960s, the IRS was at the absolute forefront of automated data processing. They adopted a machine called the IBM 7074.
I was reading about the IBM 7074 in the background materials, and we are not talking about a sleek little server rack sitting in a closet. The data storage for this machine was the size of a large living room.
It was massive.
It held an estimated 500 miles of magnetic tape. It was a mechanical behemoth. They built a centralized enterprise computing center in Martinsburg, West Virginia. The physical logistics of this operation were staggering. Once a week, massive reels of magnetic tape were literally loaded onto airplanes.
Flown in from all over the country.
Exactly, flown in from regional service centers. And in Martinsburg, the IRS employed a localized workforce of 600 clerical workers. Their entire job, day in and day out, was to operate key punch machines, physically punching holes into cardboard cards.
Unbelievable.
They were punching 50 to 60 million cards annually. At the time, that was the absolute state of the art. The IRS had officially entered the computing age and set the gold standard for how the government handled immense volumes of data.
Which sounds like an incredible achievement for the 1960s. But fast forward to the present day, and that early pioneering spirit has become a massive liability.
A huge liability.
The National Taxpayer Advocate's blog outlines a staggering statistic. The IRS currently operates 231 legacy IT systems. And in the context of these reports, the IRS does not use the word legacy lightly. They define a legacy system as one that is at least 25 years old.
25 years in the realm of technology is multiple lifetimes. A quarter of a century ago, smartphones didn't even exist. Yet, these 231 systems form the backbone of our national revenue collection.
Right.
And the real crisis is the language these systems speak. They are running on profoundly obsolete programming languages. The reports specifically highlight assembly language code, often referred to as ALC, and COBOL.
COBOL.
Yeah. These are languages that were taught in university computer science departments decades ago.
To ground this for you, the listener, we are talking about the core system that matches your W-2 from your employer to the tax return you file. The system that calculates the math, checks for basic fraud, and authorizes the Treasury to deposit your refund into your bank account.
About the one.
That system is running on code that was written before the moon landing.
And that creates a critical human capital crisis. Today, you are incredibly hard-pressed to find a living, working programmer who possesses the specialized knowledge to write, debug, or even comprehend assembly language code.
They're just not out there.
No. The original architects who built these systems, the people who understood the idiosyncratic logic of how the code was structured, have long since retired or passed away.
So you have this massive engine processing, roughly $3.5 trillion in federal revenue every year, and it is running on a language that is effectively dead.
It's terrifying when you really think about it.
It is. But the sources do make it clear that the IRS is not just sitting around waiting for the system to crash. They have launched a massive, years-long modernization effort called the CAID-2 program. I saw the acronym, Customer Account Data Engine 2, but what is that actually doing?
The K2 program is the agency's overarching initiative to modernize what they call the individual master file. The individual master file is exactly what it sounds like. It is the central database containing the tax records of every single individual taxpayer in the country. The goal of CAID-2 is to migrate over 90% of that ancient legacy core code over to Java. Java is a modern, widely understood, highly supported programming language.
But if they know they need to move to Java, why is it taking over a decade to do it? Why can't they just hire a bunch of software engineers, translate the old code into the new code, and flip a switch?
Because it is never that simple when you're dealing with a live environment of this scale. The IRS Chief Information Officer at the time described the modernization effort with a brilliant analogy. It is like trying to fix an airplane while you are flying it at 10,000 feet.
You can't just ground the IRS for a year to install software updates. The economy would completely collapse.
Precisely the issue. They have to process hundreds of millions of tax returns, process payments, and issue refunds every single year without a single interruption. But it goes even deeper than that. The tax code is not static. Every single year, Congress passes new legislation that changes the tax laws.
Sometimes multiple bills a year.
Exactly. So the IRS has this tiny, dwindling cadre of veteran experts who still understand the old assembly language code. Whenever a new tax law is passed, those experts have to dive into the 60-year-old code to write new updates and patches to accommodate the new law.
Wow.
While they are doing that, they are simultaneously trying to help the modernization team translate that same old code into the new Java system. They are trying to build a brand new engine, but they constantly have to stop and apply duct tape to the old engine just to keep the plane from falling out of the sky.
And reading through the operational plans,
Yeah.
it becomes clear that it's not just one monolithic computer they're dealing with. The IRS is fractured into dozens of divisions, and the reports highlight a really compounding problem. The agency uses approximately 60 different distinct case management systems across its various departments. And the truly alarming part is that these systems generally lack the ability to communicate with each other.
This lack of integration is a source of immense friction for both the IRS employees trying to do their jobs and the taxpayers caught in the machinery. Consider a typical dispute scenario. Let's say your tax return gets flagged and your case starts in the examination division.
That's the audit arm of the IRS.
Right. The auditor reviews your documents, makes a determination, and enters all their notes and findings into the examination case management system. Now, let's say you disagree with their findings, which is your right, and you appeal the decision. Your case now moves to the appeals division.
And because those 60 systems don't seamlessly integrate, what happens to all the auditor's notes?
Because the systems do not talk to each other, the digital file cannot just be transferred over. Instead, An IRS employee often has to open the file in the examination system on one screen and physically manually re-enter the data, the case history, and the notes into the separate appeals case management system on another screen.
The potential for human error in that scenario is astronomical. A clerk accidentally transposes two numbers while manually typing your case history, and suddenly your entire appeal is jeopardized because the data is wrong.
It happens all the time.
But speaking of manual data entry, there's a statistic in the 2024 National Taxpayer Advocate blog that completely stopped me in my tracks. It is the paper problem.
Oh, the paper problem.
In the year 2023, the IRS was still processing roughly 30 million paper individual income tax returns. And how are they getting the information off those pieces of paper into the computer? They literally had IRS submission processing employees sitting at metal desks, staring at physical pieces of paper and manually retyping the numbers,
Digit by digit.
keystroke by keystroke, into the IRS computer network.
30 million returns. And that does not even include the millions of complex, multi-page business tax returns filed on paper. The sheer volume of manual data entry required is mind-boggling. It is the absolute primary bottleneck that creates the massive backlogs and delayed refunds that make headlines every spring. The IRS knows this is unsustainable, which is why they have aggressively launched the Zero Paper Initiative. The goal is to digitize their operations by finally implementing optical character recognition technology. Instead of a human typing the numbers, a high-speed scanner takes a picture of the paper return, and software automatically reads the numbers and inputs them into the system.
But the reality is, the IRS does not have the internal infrastructure to scan tens of millions of documents overnight. To clear this historic backlog, they have been forced to outsource a significant portion of this scanning operation to private third-party contracting companies.
Which introduces a whole new set of problems.
Exactly. When you let private companies handle the most sensitive financial data of American citizens, you introduce terrifying new vulnerabilities. The 2025 report brings up a highly specific, deeply cautionary tale that illustrates this risk perfectly. It involves an IRS contractor employee named Charles Littlejohn.
The Charles Littlejohn case is a watershed moment for IRS data security. In their desperation to process the paper backlog, the IRS handed over thousands of physical, highly sensitive taxpayer returns to a private consulting firm.
Okay.
Littlejohn, who was working for that private contractor, managed to exploit his access. He systematically stole the tax return information of thousands of taxpayers, which included the data of very high-profile, ultra-wealthy individuals.
And he leaked it.
He illegally leaked that confidential data to national media outlets.
It is a profound violation of the public trust. When you send your tax return to the government, you operate under the absolute assumption that it is a locked vault.
And that leak exposes the agonizing tension the agency operates under. On one hand, they absolutely desperately need outside technological help and private sector speed to digitize the paper backlog and modernize their infrastructure. But on the other hand, every single time they allow an external vendor to touch the data stream, they introduce severe operational, legal, and confidentiality risks.
Which is why the National Taxpayer Advocate issued that stark warning.
She did. In her report, she explicitly advised the IRS not to eliminate their own internal federal submission processing employees until they can fully, undeniably validate that this new outsourced scanning technology is not only effective, but completely unassailably secure.
So how does this technological time machine, the old code, the broken case systems, the paper bottlenecks, actually impact you, the listener, right now?
Oh.
The reports offer a perfect, frustrating example. Let's say you are a divorced parent.
Okay. Very common scenario.
You are the custodial parent of a child, and you need to amend your tax return to allow your ex-spouse, the non-custodial parent, to claim that child as a dependent for the year. You go online and you electronically file your amended return, which is a Form 1040X. The electronic filing goes through instantly.
Right.
However, to legally release that dependency exemption, you are required to attach a very specific document called Form 8332.
And this is where the system shatters. The electronic return processing arm of the IRS often cannot accept that specific Form 8332 as an electronic attachment. So you are forced to print it out and physically mail it in via the Postal Service.
So now your tax return exists in two separate dimensions.
Exactly.
The electronic amended return is flying through the digital system, but the paper form validating it is sitting in a mailroom somewhere.
Because the paper processing system is entirely segregated from the e-file system, the two do not seamlessly communicate. The digital audit arm of the IRS might see your amended return, realize a Form 8232 is missing from the digital file, and automatically flag your account.
They freeze it.
They might send out a notice of deficiency or freeze the processing of both your return and your ex-spouse's return. Meanwhile, the physical piece of paper you mailed is sitting in a pile, waiting for a human to scan it, process it, manually match it to your digital file, and clear the flag.
That's madness.
A simple change of dependency can cause massive delays, immense confusion, and potential audit actions for two separate households, entirely because a physical piece of paper cannot automatically catch up to a digital file in a fundamentally fractured system.
It paints a very sobering picture. The IRS is essentially trying to run a dynamic 21st century global economy on 20th century infrastructure. Which brings us to the most obvious question anyone would ask. If the technology is this bad, why don't they just buy better technology?
I know.
Well, that leads us directly into our next focus area. We need to talk about the $80 billion question, the funding, the agile procurement strategies, and the intense cyber defenses required to upgrade this machine.
At the end of the day, funding is the lifeblood of any modernization effort. You cannot buy new technology without money. And the historical context here is vital. For decades, the IRS has suffered from chronic, severe underfunding. If you look at the period between 2010 and 2020, the agency's funding was actually reduced by nearly 20% when you adjust for inflation. They were asked to do increasingly more with significantly less. But then, a massive legislative shift occurred. The Inflation Reduction Act, commonly referred to as the IRA, was signed into law.
The IRA.
This legislation provided the IRS with an unprecedented infusion of cash, nearly $80 billion in supplemental funding distributed over a 10-year period.
$80 billion. When you hear a number like that, it sounds like all the money in the world. It sounds like they could afford to buy every state-of-the-art server farm on the planet and hire every single Java programmer out of Silicon Valley. But the National Taxpayer Advocate took a very analytical, critical look at exactly how that $80 billion was legally allocated within the agency.
And she raised some serious alarms about the structure of that funding.
Now, regardless of where anyone stands on the politics surrounding the passage of the Inflation Reduction Act, the sheer operational reality of how those funds are distributed is what we need to examine. We are just looking at the math and the logistical impact on the agency's ability to function.
And when you break down the math, the allocation is quite striking. The IRS budget is generally divided into four primary accounts: taxpayer services, enforcement, operations support, and business systems modernization.
Okay, 4 buckets.
Of the nearly $80 billion provided by the legislation, an overwhelming 90% of it was strictly earmarked for enforcement and operations support. To put numbers to it, that is $45.6 billion dedicated to enforcement, hiring auditors and pursuing tax evaders, and $25.3 billion for operations support, which largely funds the infrastructure supporting those enforcement efforts.
So 90% of this historic windfall is locked into the enforcement side of the house. What was left for everything else?
Only 10% was allocated to the remaining two categories combined. Just $3.2 billion went to taxpayer services, which funds the people who actually answer the phones, run the taxpayer assistance centers, and help everyday people navigate the system.
Oh.
And only $4.8 billion was allocated to business systems modernization, which is the exact fund required to upgrade the ancient technology we were just discussing.
The National Taxpayer Advocate looked at this distribution and essentially said the ratio of enforcement funding to taxpayer service funding is dangerously out of balance.
Her argument is rooted in operational efficiency. It is an analytical fact that you simply cannot audit your way out of the tax gap. The IRS estimates that the tax gap, which is the difference between the amount of tax legally owed to the government and the amount actually paid on time, is roughly $470 billion every single year.
$470 billion.
Now, robust enforcement is absolutely necessary to ensure fairness and to deter willful tax evasion. However, enforcement is inherently a back-end solution. It only happens after the mistake has been made or after the fraud has already occurred. Audits are incredibly expensive, time-consuming, and adversarial.
Oh, they are.
The advocate forcefully argues that the most efficient, cost-effective method to improve compliance and shrink that tax gap is by helping taxpayers get it right the first time on the front end. If you invest heavily in clear guidance, if you have enough staff to answer the phones immediately, and if you build modern digital systems that catch mathematical errors instantly before the return is even accepted,
You prevent the non-compliance from ever happening in the first place.
Exactly.
It is the classic paradigm. An ounce of prevention is worth a pound of cure. And when you isolate that technology budget, the $4.8 billion stretched over 10 years, it really puts the agency struggle into perspective, especially when you compare the IRS to the private financial sector. The reports draw a fascinating parallel. Large U.S. commercial banks, the institutions managing our checking accounts and mortgages, spend between $10 billion and $14 billion every single year on technology and IT upgrades.
One bank spending $14 billion a year.
Right. Meanwhile, the IRS, an agency that serves a significantly larger customer base and processes infinitely more complex financial data than any single bank, received an annual appropriation of just $275 million for business systems modernization in fiscal year 2022. It is an absurd comparison. It is like comparing the budget of a local lemonade stand to a multinational beverage corporation.
The downstream effect of that severe funding disparity is that the IRS has to be incredibly smart, agile, and ruthlessly efficient with the modernization money they do possess. They simply cannot afford to get locked into massive, bloated, decade-long IT contracts that inevitably fail to deliver on their promises. They have to change how they buy technology.
Here's where it gets really interesting. To solve this procurement problem, the IRS has created a completely new strategy called Pilot IRS. I dug through the specific internal web pages detailing this program, and it represents a massive cultural and procedural shift in bureaucratic thinking. Historically, if a government agency wanted to test out a new piece of technology, they were bound by something called a bailment agreement.
Yes, the dreaded bailment agreement. A bailment agreement is a very formal, traditional, and excruciatingly slow legal arrangement that governs the use of property or software for testing purposes. The fundamental flaw with bailment agreements in the tech sector is the timeline.
It just takes too long.
It can take a year or more just for the government lawyers and the corporate lawyers to negotiate the terms of the agreement. By the time the ink is dry and the testing can begin, the technology itself might already be outdated.
Of course.
Furthermore, this slow, arduous process inherently limits the IRS to working almost exclusively with known entities, the massive defense contractors or established legacy tech giants. A small, innovative startup firm simply does not have the legal resources or the capital runway to survive a 2-year negotiation process just for the opportunity to test their product.
Enter Pilot IRS. This program essentially throws the traditional bailment agreement out the window when it comes to technology testing. Pilot IRS utilizes a concept called agile modular contracting. It leverages existing but rarely used flexibilities within the federal acquisition regulation to dramatically lower the barrier to entry.
Which is huge.
If a nimble tech startup has developed a cutting-edge artificial intelligence tool for scanning handwritten documents, or a revolutionary new cloud security protocol, the IRS can use the Pilot IRS framework to bring them in and actually start testing their solution in a live, controlled environment in a matter of weeks, or sometimes even days.
It is a profound shift toward outcome-based procurement. They test the technology in small, incremental phases. And the absolute beauty of this modular approach is that it embraces the Silicon Valley concept of failing fast.
Right.
If a vendor's software solution does not perform as promised during the initial pilot phase, the IRS figures that out almost immediately. They cut the funding for the next phase, terminate the contract, and move on to the next solution. They do not get trapped in a 10-year, multi-billion-dollar boondoggle that produces nothing.
You just move on.
Conversely, if a solution does work brilliantly, the modular nature of the contract allows the IRS to rapidly scale it up, fund the next phase, and deploy it across the enterprise. It completely opens the competitive landscape to non-traditional vendors and small business firms, which drives down overall costs and injects fresh, much-needed innovation into the agency.
But hold on a second. If the agency is suddenly bringing in all these new, relatively unknown tech startups, rapidly testing new cloud solutions, and integrating modular software components in a matter of days or weeks, how on earth do they keep the taxpayer data safe? We just discussed the catastrophic Charles Littlejohn leak. Security cannot be an afterthought.
And it absolutely is not. The IRS has published incredibly strict, highly specific cybersecurity requirements that any contractor must adhere to if they want to do business with the agency, especially through these modern, fast-paced procurement channels. The speed of the Pilot IRS program does not equate to a relaxation of security standards. Paradoxically, it requires a much more rigorous, automated, and continuous security posture.
I was looking at the scanning, compliance, and vulnerability requirements document that the IRS mandates, and it is intense. If you are a software developer providing a solution to the IRS, you do not just build the code, hand it over on a flash drive, and walk away. I noticed there were requirements of a continuous automated scanning. How does that work in practice?
Contractors are legally mandated to perform automated asset discovery and comprehensive vulnerability scanning across the entire network boundary on a highly aggressive schedule, usually every 7 to 14 days.
Wow.
Every single fortnight, the contractor must run automated tools to prove their system is clean and report those findings. Furthermore, they mandate the use of the Common Vulnerability Scoring System, or CVSS, to objectively assign a risk score to any vulnerabilities that are discovered. If a major software vendor globally releases a signature update to patch a newly discovered flaw, the contractor must update their internal vulnerability databases within 24 hours. It is an environment of continuous, aggressive, unrelenting monitoring.
The documents also heavily emphasize something called an SBOM, a software bill of materials. For anyone listening who might not be a software engineer, think of an SBOM like the ingredients label on the back of a box of cereal.
That's a great way to put it.
When a company builds a modern piece of software, they almost never write every single line of code from scratch. They use dozens, sometimes hundreds, of open-source libraries and third-party code snippets to build their application faster. An SBOM forces the contractor to provide the IRS with a comprehensive list of every single ingredient inside their software.
Right.
That way, if a major security vulnerability is discovered in some random, obscure open-source library on the other side of the world, the IRS doesn't have to guess if their systems are at risk. They can instantly query their SBOM database, see exactly which contractors are using that specific compromised ingredient, and immediately force them to patch it.
The requirements also drill deeply into application development security. Contractors are required to implement continuous static code analysis and formal, rigorous code reviews to prevent what the industry refers to as the OWASP Top 10 vulnerabilities. OWASP stands for the Open Worldwide Application Security Project, and their top 10 list represents the most critical, prevalent security risks to web applications globally.
So they are looking for things like SQL injections, right? Where a malicious hacker types specific database commands into a standard website form like a login box, trying to trick the backend server into dumping all of its confidential data onto the screen.
Exactly the kind of threat they're mitigating. The IRS requires contractors to integrate these vulnerability scanning tools directly into their CI/CD pipeline. CI/CD stands for Continuous Integration and Continuous Deployment. It means the code is automatically tested for security flaws every single time a developer writes a new line, before that code is ever allowed to be pushed into a live production environment.
That's robust.
On top of all these automated checks, the IRS mandates independent third-party penetration testing before any system is allowed to go live, and annually thereafter. They are quite literally hiring teams of ethical hackers to aggressively attack the software using real-world cyber warfare scenarios to find the weak spots and break the system before a hostile nation-state or a criminal syndicate does.
So we have this incredibly fascinating dynamic. On one hand, you have this sophisticated, agile, cyber-hardened modernization effort slowly spinning up with Pilot IRS. But on the other hand, you still have the massive anchor of the legacy systems, the ALC code, and the 30 million paper returns dragging the agency down. It is a slow-motion collision of two entirely different eras of technology.
A collision is exactly what it is.
And that collision is heading straight for an unprecedented stress test. So you have this incredibly vulnerable 60-year-old tech infrastructure. That alone is a crisis. But when you realize the IRS is about to stress test that exact system with a severely depleted workforce and a tidal wave of massive new tax laws next year, it starts to look like a perfect storm. We need to talk about the impending 2026 perfect storm.
To truly comprehend why the landscape of 2026 is looking so ominous, we first have to establish the baseline of what a good year looks like. According to the National Taxpayer Advocate's report, the 2025 tax filing season was, objectively speaking, quite successful. The system held together, taxpayers generally fared well, returns were processed within normal timeframes, and refunds went out smoothly for the vast majority of people who filed electronically.
And why was 2025 considered a success? Because, for once, the stars actually aligned for the agency. The IRS entered the 2025 filing season with a relatively robust, well-staffed workforce hovering around 102,000 total employees. And critically, there were no major, chaotic, last-minute tax law changes that Congress forced them to implement right in the middle of the filing season. They had the necessary human capital, and they had legislative stability.
But as Erin M. Collins warns with deep concern in her 2025 annual report, the landscape entering the 2026 filing season is markedly, terrifyingly different. The IRS is simultaneously confronting two massive opposing forces that threaten to buckle the system.
The first force is the workforce.
Yes. The first force is a catastrophic reduction in human capital. While they started 2025 with 102,000 employees, the reports indicate they're entering 2026 with only about 74,000 employees. That is a staggering 27% reduction in their total workforce in a single calendar year.
Let that sink in for a moment. A 27% drop. That is more than 1 out of every 4 employees, completely gone. And this reduction hits the front lines, the people interacting directly with the public, the hardest. The number of customer service representatives, the CSRs, the people whose literal job is to answer the phones when you call in a panic because your refund hasn't arrived, dropped by 22%.
It's a huge hit to taxpayer service.
Now, the agency did manage to backfill some of those positions late in the year, but you cannot instantly replace a 15-year veteran with a new hire. The new employees inherently lack the deep institutional knowledge and the intuitive understanding of the complex tax code that the departing veterans took with them.
So you are facing the filing season with a severely depleted, vastly less experienced workforce. That is only the first half of the storm. The second half of the storm is the legislative environment. Congress recently enacted a massive, sweeping piece of legislation, which is referred to in the reports we are analyzing as the One Big Beautiful Bill Act.
Regardless of the political intent behind the legislation, from a purely operational standpoint, it requires a massive logistical pivot. What happens when you drop this kind of legislation on an agency that just lost a quarter of its staff?
Analytically speaking, the operational impact is profound. The Act introduced over 100 distinct changes to the federal tax code. And the most crucial disruptive element is that while some provisions do not take effect until later years, many of the most significant provisions were made retroactive to the beginning of 2025.
Retroactive.
This means that these brand new, highly complex rules must be calculated and reported on the 2025 tax returns that taxpayers are preparing and filing right now during the early 2026 filing season.
The logistics of that are mind-bending. The IRS has to instantly reprogram their legacy computers to accept these new laws, draft entirely new guidance documents, physically change the layout of the tax forms, rewrite the hundreds of pages of instructions, and somehow educate the American public on how to comply, all with 27% fewer people to do the work.
And the specific nature of these newly enacted laws creates a unique, incredibly heavy administrative burden. The advocate points out in her analysis that the One Big Beautiful Bill Act is, generally speaking, heavily taxpayer favorable. It significantly expands eligibility for certain deductions and introduces new financial benefits, such as new deductions for tip income, specialized deductions for overtime pay, and an increased standard deduction for senior citizens.
That's great on paper.
However, these financial benefits are not universally applied. They are subject to incredibly complex eligibility rules, convoluted income thresholds, and complicated phase-out formulas.
To really show you how burdensome this complexity is for the average person, let's look at one of the prime examples from the report, the new auto loan interest deduction. On the surface, it sounds amazing. You buy a car, you deduct the interest on the loan. It sounds like free money from the government. So let's say I want to use this deduction. I just go buy a reliable used car to get to work and write off the interest, right?
You would naturally assume so, but no. That brings us to the first roadblock. Under the specific text of the new law, the vehicle must be brand new. Used car purchases are immediately legally disqualified from the deduction.
Okay, fine. I buy a brand new car, but cars are expensive, so I use it for my side hustle driving for a rideshare company on the weekends to help make the payments.
Disqualified again. The law strictly dictates that the vehicle must be purchased exclusively for personal use. If you use it for any business purpose, it does not qualify.
All right, new car, personal use only, and I bought it last Thanksgiving in 2024, so I can start deducting the interest now.
Unfortunately, no. The loan must have originated strictly after December 31st, 2024. Your Thanksgiving purchase is ineligible. Furthermore, the loan must be formally secured by a lien on the vehicle itself. You cannot just take out a personal unsecured signature loan from your bank and use those funds to buy the car.
Okay, so I meet all those rules, but I need a big truck to haul my boat.
You have to watch the weight. The vehicle must have a gross vehicle weight rating of less than 14,000 pounds. And when you file your return, you are required to include the specific vehicle identification number, the VIN, directly on the tax form for verification.
Fine, I buy a normal-sized sedan, and my wealthy uncle offered to loan me the money at a great interest rate, so I'll just deduct the interest I pay him.
That violates the related party rule. The loan must not have been obtained from a related party. You must use a traditional, independent financial institution. And here's the rule that trips up almost everyone. The vehicle must have undergone final assembly in the United States.
final assembly in the U.S. How is the average person standing on a car lot supposed to know the global supply chain logistics of where the final bolt was tightened on their sedan?
It's almost impossible for a consumer to easily verify.
And even if I miraculously navigate all 8 of those rules, there's a limit to how much I can deduct, right?
Yes. The deduction is strictly capped at a maximum of $10,000. But more importantly, it is subject to severe income phase-outs. It phases out based on your modified adjusted gross income.
Let's clarify that term because it's everywhere in tax law. Modified Adjusted Gross Income, or MGI. For most everyday people, your MGI is basically just your total income for the year, minus a few very specific above-the-line deductions like student loan interest. So how does the phase-out work?
For a single filer, the ability to claim the deduction begins to phase out if your MGI rises over $100,000. It incrementally decreases and it completely disappears. It fully phases out once your income hits $150,000. If you make $150,001, you get absolutely nothing.
Just going through that exercise illustrates the madness. This brings us to a really uncomfortable reality about how tax policy is designed. The Advocate's report highlights this fascinating concept, the paradox of favorable tax laws.
It's a real phenomenon.
Even when a law is specifically intentionally designed to give taxpayers a financial benefit, if the rules governing who gets that benefit are too complex, it creates immense confusion. Taxpayers look at their situation, they don't know if their car qualifies, they don't know how to calculate their MAGI, so what is their immediate reaction? They pick up the phone and call the IRS for help.
But remember the first half of the storm. The IRS just lost 22% of its customer service representatives. So this immense legislative complexity drives a massive, predictable spike in phone calls at the exact moment the agency's workforce is least equipped to answer them.
The timing couldn't be worse.
Furthermore, taxpayers who decide to guess and try to claim the deduction but inevitably make a mistake on one of those 8 convoluted rules will trip the automated security filters within the IRS processing system. The legacy computers will flag the return as potentially erroneous, automatically halt the processing, and freeze the taxpayer's refund. Releasing that freeze requires manual intervention.
An actual person.
An IRS employee has to physically review the file, send a letter requesting documentation, verify the VIN, check the loan origination date, calculate the phase-out, and manually release the funds.
It creates a cascading systemic failure. A favorable law creates immense complexity. Complexity inevitably creates taxpayer errors. Those errors trigger the automated filters. The filters freeze the refunds. The frozen refunds generate massive anxiety, which causes millions of desperate taxpayers to call the IRS. And the depleted workforce simply gets buried under the avalanche.
It's exactly what the reports warn about.
And here's why you need to care about this, even if you take public transit and have zero intention of ever claiming the auto loan interest deduction. Let's say your tax return is incredibly simple. You have one W-2, you take the standard deduction, you file it in 5 minutes. You are still standing in the exact same digital processing line as everyone else. If millions of other people get their complex returns flagged and frozen, they're going to clog the entire IRS processing infrastructure. The backlog grows, the processing servers slow down, and your perfectly simple, flawless tax return gets delayed in the bureaucratic traffic jam.
The 2026 perfect storm is ultimately a massive test of systemic resilience. Will the new optical scanners, the Java code migrations, and the agile pilot IRS technology upgrades be enough to offset the devastating loss of 28,000 employees and the crushing administrative burden of 100 new retroactive tax laws?
That's the billion-dollar question.
And the National Taxpayer Advocate, looking at the data, is deeply concerned that the technology will not be able to bridge the gap in time.
And when the system inevitably buckles under that pressure, what exactly does that look like for the person on the ground? What happens to the taxpayer? To understand that, we look at the core of the NTA's mandate. Every year, the National Taxpayer Advocate is legally required by Congress to submit a report detailing the 10 most serious problems encountered by taxpayers. When we synthesize the findings from both the 2024 and 2025 reports, we see a very clear, agonizing picture of chronic pain points.
We really do.
Let's start with what is arguably the absolute nightmare scenario in the modern tax system: identity theft.
Tax-related identity theft has been a persistent threat for years, but the sheer length of the delays in resolving these cases has reached a breaking point. The mechanism of the fraud is straightforward. A criminal syndicate steals your Social Security number, often from a data breach completely unrelated to the IRS. They file a fabricated tax return in your name early in the season, claiming massive fake deductions, and they pocket a fraudulent refund.
And then you go to file.
Weeks later, when you sit down to file your legitimate tax return, the e-file system rejects it, stating a return has already been filed under your SSN. You have officially become a victim of tax-related identity theft. And according to the grim statistics in the 2025 report, hundreds of thousands of innocent victims are currently waiting an average of over 21 months for the IRS to resolve their identity theft victim assistance cases and issue their actual legitimate refunds.
Over 21 months. Think about the reality of that timeline. The advocate uses the word unconscionable to describe these delays, and it is entirely justified. Imagine a low-income family. They rely on their $3,000 tax refund every single year to repair their only vehicle, catch up on past due rent, or pay off medical debt. When a fraudster steals their identity, the IRS freezes their money. Telling that family they have to wait almost 2 years to receive the money they desperately need to survive can completely devastate their financial stability.
Another area experiencing massive systemic delays involves amended returns. If you file your tax return and later discover you made an honest mistake, perhaps you forgot to include a deduction you were entitled to, or you received a late tax form in the mail, you must file a Form 1040X to correct the record. If you are expecting a refund based on that correction, you are going to be waiting a very long time.
How long?
In fiscal year 2025, the IRS took an average of over 13 months to process amended returns for businesses. For individual taxpayers, it took an average of over 5 months to process the 3.7 million amended returns sitting in the inventory.
And the process gets incredibly murky if the IRS disagrees with your correction. If the IRS reviews your amended return and decides to disallow your claim, meaning they formally refuse to issue the additional refund you requested, they send out a disallowance notice. The NTA reports state that these notices are often terribly drafted and incredibly confusing.
They are very legalistic.
But the most egregious failure is that they frequently fail to clearly state the strict statutory legal deadline by which the taxpayer must file a lawsuit in federal court to contest the IRS's decision. If you read that confusing notice, set it aside to deal with later, and accidentally miss that unstated deadline, you permanently, irrevocably forfeit your legal right to ever claim that refund.
It represents a severe breakdown of fundamental due process and taxpayer rights. And the reports highlight another critical area where rights are being compromised: the right to representation. When taxpayers find themselves facing a complex audit or aggressive collection actions like wage garnishments, they have a fundamental codified right to retain representation. They have the right to hire a tax professional, a CPA, an attorney, or an enrolled agent to step in and fight the IRS on their behalf.
But the digital infrastructure supporting those tax professionals is failing. The IRS created a portal called the Tax Pro account, but the reports note it lacks basic critical functionality.
It does.
But the real systemic failure lies within the authorization database, historically known as the centralized authorization file. When you hire a CPA, you sign a specific form granting them power of attorney, legally stating, "This person is authorized to speak to the IRS on my behalf." That form has to be manually processed and recorded into the agency's authorization database.
And if that authorization database experiences a systemic crash, or if it becomes massively backlogged because of the paper processing issues we discussed earlier, the consequences for the taxpayer are dire. When the CPA calls the IRS to defend their client, the IRS employee looks at their screen, sees no record of the authorization, and legally must refuse to speak to the representative.
Wow.
The database failure effectively strips the taxpayer of their right to representation at the exact terrifying moment they need it most while facing an auditor or trying to stop a bank levy.
We also need to shine a light on a group of taxpayers who experience a very unique kind of misery: U.S. citizens living abroad. The reports detail how expats face incredibly severe, almost punitive compliance burdens. The United States is one of the only countries in the world that taxes based on citizenship rather than residency.
Right.
So expats are living their daily lives under foreign legal systems, dealing with foreign banking regulations, yet they remain fully subject to the staggering complexities of the U.S. tax code. They face massive international information reporting requirements, forms that are incredibly difficult to understand.
It's a compliance nightmare for them.
The advocate notes that they frequently face harsh, disproportionate financial penalties just for making good-faith accidental mistakes while trying to navigate the intersection of two entirely different countries' tax systems. Furthermore, the IRS processes designed to offer relief from international withholding requirements are described as agonizingly slow.
But of all the systemic problems analyzed in these reports, there is one operational failure that is truly mind-bending because it is entirely self-inflicted. It involves the failure of the level of service metric. What's fascinating here is how measuring the wrong metric and obsessing over it actively breaks the entire functional system.
This is perhaps the most revealing insight in the entire deep dive, because it perfectly illustrates what happens when bureaucratic optics take precedence over actual problem solving. Historically, the IRS has used a metric called level of service, or LOS, as their primary public benchmark for success. When the IRS commissioner testifies before Congress, LOS is the number they tout. And LOS simply measures the percentage of incoming phone calls that get answered by a live human being.
On the surface, it sounds like an excellent taxpayer-friendly metric. Of course, you want people to answer the phone when taxpayers call, but here is the fatal structural flaw in how the IRS operates. During the intense months of the filing season, the agency utilizes the exact same pool of customer service representatives to perform two entirely different jobs. They use the same people to answer the incoming phone calls and to process the massive backlog of taxpayer correspondence and paper casework. And because of the limitations of their systems, they cannot seamlessly shift an employee back and forth between answering a call and working a complex paper case.
So if the agency's management is under intense political pressure to ensure that the level of service metric stays artificially high for the reports to Congress, what do? They force these representatives to stay logged into the phone routing system, essentially chaining them to the phone, waiting for calls to come in.
Exactly.
The 2025 report reveals a statistic that is almost hard to believe. During the filing season, customer service representatives spent 34% of their total working time just sitting idle, waiting for the phone to ring.
Let's quantify that. In 2023, that 34% translated to nearly 1.3 million hours of idle time. These are highly trained, fully paid federal employees sitting at their desks, staring at their screens, doing absolutely nothing, just to ensure that if a call does happen to come in, it gets answered on the first ring. They are sacrificing millions of hours of productivity strictly to keep the LOS metric high.
But remember that massive, crushing backlog of 30 million paper returns and millions of amended returns we talked about earlier, the files that are taking 13 months to process. If those customer service representatives had been allowed to log off the phone queues during slow periods and utilize that 1.3 million hours of idle time to process the paper inventory sitting in the room next to them, the advocate mathematically calculates they could have processed and closed more than 1.5 million additional cases.
It creates a vicious, self-perpetuating cycle of failure. The agency prioritizes answering the phones over processing the paperwork. Because the paperwork does not get processed, the refunds are infinitely delayed. Because the refunds are delayed, anxious, desperate taxpayers pick up the phone and call the IRS to ask where their money is.
Which floods the phone lines again.
These millions of status check calls flood the phone lines. Management sees the flood of calls, panics about the LOS metric dropping, and forces even more employees onto the phones. This further starves the paper processing teams of manpower, which causes even longer delays, which inevitably generates even more angry phone calls. Obsessing over a high level of service on the phones is actively, demonstrably harming the overall speed of the agency. They are sacrificing actual case resolution just to hit a call center vanity metric.
And as if the agency did not have enough internal, self-inflicted problems to deal with, the 2025 report points out a massive, growing external threat that is poisoning the system: social media tax influencers.
This represents a modern, highly pervasive direct threat to tax compliance. As younger generations enter the workforce, they are increasingly turning away from traditional tax professionals and turning toward platforms like TikTok, Instagram, and YouTube for financial and tax advice.
Yeah, I've seen them.
And what they are finding is a wild west of influencers who are aggressively pushing highly questionable and often entirely illegal tax strategies. And they do it without providing any legal context, verification, or assuming any professional accountability.
We've all seen the videos. Someone standing in front of a leased luxury car telling you, just write off your G-Wagon. Create an LLC, declare your dog an employee, and deduct your groceries as a business expense. They package tax fraud and present it as a clever life hack.
And that framing is incredibly dangerous. These influencers exploit widespread financial illiteracy and weaponize the immense complexity of the tax code. They use confident, authoritative tones to convince average, well-meaning taxpayers to claim massive credits or business deductions they absolutely do not legally qualify for. This leads to thousands of disastrous, fundamentally fraudulent tax filings.
That fallout must be terrible.
The tragic outcome is that the taxpayer eventually gets audited, faces massive financial penalties, and potentially criminal charges. Meanwhile, the influencer who gave the advice faces absolutely zero consequences because they are not the ones who legally signed the fraudulent return under penalty of perjury. They just collected the ad revenue from the video and moved on.
It is a remarkably dark landscape out there. When you step back and look at the whole picture, you have antiquated computers running dead languages, a shrinking workforce drowning under 100 new retroactive laws, families waiting 21 months for identity theft resolution, and TikTokers tricking young people into committing federal tax fraud. It feels overwhelming. So who is actually fighting back against the chaos? What are the actual tangible solutions being proposed? That brings us to our final core area, the Purple Book and the protectors.
The primary institutional protector of the taxpayer within this massive, grinding bureaucracy is the Taxpayer Advocate Service, or TAS. As we established, they operate as an independent organization nested within the IRS. Their entire mandated mission is twofold. First, to help individual taxpayers resolve intractable problems when the normal IRS channels completely break down.
And
Second, to analyze the data and recommend systemic structural changes to prevent those problems from happening to anyone else in the first place.
And their most powerful weapon in driving that systemic change is a document called the Purple Book. Every single year, alongside the massive annual report detailing the problems, the National Taxpayer Advocate submits the Purple Book directly to Congress. It is a highly focused, concise summary of legislative recommendations. The 2026 Purple Book contains 71 specific, actionable proposals that Congress could vote to pass tomorrow to fix the underlying machinery and strengthen taxpayer rights.
Let's examine a few of the most critical proposals in that book because they target the root causes of the dysfunction. One of the most urgent, repeated recommendations is for Congress to explicitly authorize the IRS to regulate non-credentialed tax return preparers.
This addresses the ghost preparer problem, and the statistics the advocate uses to justify this proposal are terrifying. In fiscal year 2024, the IRS estimates that 27.3% of all earned income tax credit payments issued by the government were improper. That translates to $15.9 billion in incorrect payments in a single year.
To understand the stakes, we need to understand the Earned Income Tax Credit, or EITC. It is a highly complex, refundable tax credit designed to assist low to moderate income working individuals and families. The key word is refundable. Because it is a refundable credit, if the amount of the credit you qualify for is larger than the total amount of income tax you actually owe, the government cuts you a check for the difference.
It's a vital lifeline.
It is a vital, poverty-reducing lifeline for millions of working families, but precisely because it pays out cash, it is also a massive, highly lucrative target for fraud, exploitation, and gross errors.
And who is primarily responsible for causing these massive errors? The Purple Book states that a staggering 96% of the dollar amount of EITC audit adjustments, the money the IRS had to claw back because the return was wrong, came from tax returns that were prepared by non-credentialed preparers.
The regulatory landscape for tax preparation is shockingly lax. Unlike certified public accountants, licensed attorneys, or enrolled agents, all of whom have to pass rigorous, standardized exams, maintain annual continuing education credits, and operate under strict, enforceable ethical guidelines, literally anyone can hang a neon sign in a strip mall and call themselves a tax preparer.
It's hard to believe.
There are absolutely no minimum federal competency requirements. You do not have to pass a single test or prove you have even read the tax code to charge money to prepare someone's federal tax return.
The advocate makes a brilliantly simple, common-sense comparison in her argument. In almost every state, barbers, beauticians, and motor vehicle operators all need to pass a test and obtain a license to legally work. Why on earth is the person who is handling your highly sensitive, confidential financial data and attempting to navigate the most complex federal laws in existence not required to prove they have even basic competency? The Purple Book urgently proposes giving the Treasury Department the statutory authority to establish minimum competency standards, require testing, and crucially, to permanently revoke the identification numbers of preparers who are sanctioned for incompetence or fraudulent conduct.
Another critical proposal in the Purple Book directly addresses the concept of access to justice, specifically expanding the jurisdiction of the United States Tax Court. Currently, The legal avenues available to taxpayers are highly bifurcated. If the IRS audits you, assesses additional tax, and says you owe them money, you have the right to challenge that assessment in the tax court before you pay.
Which is helpful.
Yes, the tax court is designed to be accessible, the filing fee is low, the judges are specialized tax experts, and the procedures are informal enough that many taxpayers successfully represent themselves without a lawyer. However, if the situation is reversed, if you have already paid the tax and you are suing the IRS to get a refund that they wrongfully denied, the tax court currently does not have the legal jurisdiction to hear your case.
And that jurisdictional limit creates a massive barrier. If you want to fight the government for a refund, current law forces you to file your lawsuit in a U.S. District Court or the Court of Federal Claims. The problem with those courts is that they are infinitely more expensive, the procedural and evidentiary rules are highly complex, and you generally cannot survive the litigation process without hiring an expensive, specialized trial lawyer.
It essentially creates a pay-to-play justice system.
If your disputed refund is only $5,000, but the lawyer costs $10,000 to navigate district court, you abandon the case. The government keeps your money by default. The Purple Book strongly recommends expanding the tax court's jurisdiction to explicitly include refund cases, giving every single taxpayer an affordable, accessible venue to fight for their money, regardless of whether they have already paid it or not.
We also see a profoundly important proposal regarding the strict deadlines for obtaining Social Security numbers to claim the child tax credit and the earned income tax credit. Under current law, to claim these vital family credits, the child must be issued a Social Security number by the exact due date of the tax return. The legislative intent behind this strict deadline was to stop non-U.S. persons from improperly claiming the credit, which is a logical policy goal.
But the rigid, unforgiving nature of that deadline creates tragic collateral damage for vulnerable populations. The Purple Book points out several heartbreaking scenarios. Military families stationed at bases overseas frequently face immense bureaucratic delays in getting Social Security numbers processed for their newborns. Parents navigating the complexities of international or domestic adoptions face similar delays.
Sometimes the hospital simply misplaces the paperwork.
Right. Or consider certain Amish communities who, due to deeply held religious beliefs, do not initially obtain SSNs for their children. If any of these families missed the rigid April 15th deadline simply because the federal bureaucracy was slow in issuing the card, they permanently forfeit thousands of dollars in vital tax credits that Congress fully and explicitly intended for them to have.
It's an administrative technicality causing real harm.
The advocate humanely proposes changing the law to allow taxpayers to amend their returns to claim the credits once the SSN is finally obtained, or to provide alternative, rigorous documentation to substantiate the child's identity.
But it is important to remember that the Taxpayer Advocate Service is not the only protector in the ecosystem. While TSA plays defense for the taxpayer trying to fix the broken systems, the IRS also deploys a highly aggressive offensive line dedicated to hunting down the absolute worst actors in the system. This brings us to the operations of the Office of Promoter Investigations and the Whistleblower Office.
The Office of Promoter Investigations is a specialized unit dedicated entirely to hunting down the architects of fraud, the individuals and firms who create, package, and aggressively sell abusive tax avoidance transactions. These are the people creating the incredibly complex, opaque, illegal offshore schemes that the social media influencers eventually end up promoting to the masses.
The originators.
Every single year, the IRS publishes the Dirty Dozen, which is a public awareness list of the worst, most prevalent tax scams currently circulating in the wild. But the reality is, the IRS does not have the resources to find all these shadow schemes on their own. They rely heavily on the vigilance of everyday people, and specifically on ethical tax professionals, to report these enablers using a specific document called Form 14242.
And if you happen to spot something truly massive, if you're an insider at a major corporation or a wealth management firm, there's a profound financial incentive to come forward. The IRS Whistleblower Office, which was formally established and strengthened in 2006, offers substantial, life-changing financial rewards.
How substantial?
If you possess solid, actionable evidence about a massive tax fraud scheme specifically, where the amount of unpaid taxes in dispute exceeds $2 million and the target is a high-income earner or corporation, you can submit that evidence directly to the Whistleblower Office. If the IRS successfully uses your information to investigate, audit, and collect the unpaid taxes, penalties, and interest, you are legally entitled to receive an award worth between 15% to 30% of the total proceeds collected.
15 to 30% of a multi-million-dollar recovery. Do the math on that. If your evidence leads to the recovery of $10 million, the IRS writes you a check for up to $3 million. It is a brilliant strategy. It turns honest accountants, observant administrative assistants, and disgruntled corporate insiders into highly motivated, incredibly effective deputies for the IRS, creating a powerful, ever-present deterrent against massive corporate and high-net-worth tax evasion.
It perfectly illustrates the agency's multifaceted approach to survival. You have the taxpayer advocate fighting internally for systemic fairness and legislative fixes, the whistleblower office financially incentivizing the exposure of major fraud, and the Office of Promoter Investigations actively hunting the architects of abuse.
So what does this all mean for you? We have covered an immense, almost overwhelming amount of ground today. We have looked deeply into the inner workings of an organization that literally pioneered automated computing in the 1960s, only to become hopelessly trapped by the legacy of that exact achievement.
The huge paradox.
The IRS is a massive, aging machine desperately trying to upgrade its core engine to Java while flying at 30,000 feet. They are taking a historic $80 billion infusion of capital and attempting to modernize through agile, fast-paced pilot IRS contracts, all while operating under the constant shadow of intense global cyber threats.
And the true marvel is that they are attempting to execute this unprecedented technological transformation while simultaneously shedding 27% of their workforce and being forced to digest and implement over 100 retroactive, hyper-complex tax laws. It is a vital national system operating under profound structural stress.
Absolutely.
It is a system where obsessing over the wrong call center metric can leave millions of paper returns rotting in a backlog, and where a single piece of paper can halt your financial life for months.
Ultimately, this ongoing transformation directly impacts the security of your most sensitive digital data, the speed at which you receive your refund, and your fundamental legal rights to representation and due process. The absolute biggest takeaway from digesting the National Taxpayer Advocate's reports is that in a system this strained, being relentlessly well-informed is your absolute best defense. Understanding the complex rules, avoiding the siren song of TikTok tax scammers, and comprehending exactly how the machinery of the IRS operates can save you from falling into a 21-month bureaucratic black hole.
It really can.
But before we sign off, I want to leave you with a final, provocative thought to mull over. Something that wasn't explicitly debated in the pages of these bureaucratic reports, but a question that naturally and inevitably builds on everything we have discussed about this massive technological transformation.
Okay, I'm listening.
Let us imagine a future where the IRS's multi-billion-dollar modernization effort actually succeeds perfectly. Imagine a world where all the legacy assembly code is finally rewritten and retired. Imagine the Zero Paper Initiative achieves 100% optical scanning, eliminating manual data entry entirely. And imagine that artificial intelligence becomes sophisticated enough to perfectly process, cross-reference, and audit every single tax return the millisecond it is filed.
That would be quite the future.
If that technological utopia is achieved, will the role of the human tax professional eventually become entirely obsolete? Will software simply replace the CPA?
Or conversely, we must ask the opposite question. As long as Congress continues the tradition of passing incredibly complex 100-page pieces of legislation with dozens of convoluted micro-rules, exceptions, and phase-outs, like the 8-step auto loan interest deduction we dissected earlier, will human interpretation, strategic planning, and loophole finding always remain the ultimate, unautomatable element of the tax system? Will the sheer intentional complexity of the law always guarantee the absolute necessity for a human to remain in the loop?
It is a truly fascinating question regarding the limits of technology versus the infinite complexity of human legislation. We cannot thank you enough for taking this deep dive into the source material with us today. Your time, your attention, and your relentless curiosity are what make these explorations possible. Stay informed, stay curious, and we will see you on the next deep dive.